Hi, in the previous session we have seen different types of agreements: valid agreement, voidable agreement, unenforceable agreements and unlawful agreements. In this session we are going to see in detail about these. Void agreement we will take first. Void agreement is defined in section 2 subsection G. It says an agreement not enforceable by law is void. If an agreement is not enforceable by law, it is void. But one more condition, another subsection J, 2J, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Ceases to be enforceable in law becomes void. That is, originally it is a contract, subsequently it has become a void agreement. We will take this as examples. If an agreement is entered into with a minor, it is a void agreement, because section 10 says for a valid agreement there should be a consideration, consent should be free consent, party should be a competent to contract, competent to enter into agreement, then lawful object and consideration. So, a minor has no competency to enter into a contract. An agreement with a minor is void. It is called void ab initio. From the beginning it is void. From the date of agreement it is not valid. It is a void agreement, not enforceable by law. Void. This is defined in section 2G. Then the next section says something about which ceases to be enforceable. That is, originally it is a valid agreement, originally it is a valid contract, subsequently it ceases to be enforceable. For example, there is an agreement for sale of Indian made foreign liquors like brandy, whiskey, all these things. But subsequently the government made an act stating that nobody should do this. An act prohibiting the sale of Indian made foreign liquors. So this activity has become an unlawful activity. This agreement is void from that date. It was originally a valid agreement, originally a valid contract enforceable by law, but subsequently it has become a void. We will take one more example. One person agreed to sell his cow to another person. Delivery to take place after 30 days. So after 30 days, the cow has to be delivered. Agreement is valid. It satisfied all the conditions of the contract. Consideration is there, competency to enter into a contract, object is a lawful object, consent is free, valid contract. Only thing is performance has to be taken place after 30 days. Cow to be delivered on 30 days, after 30 days, and the payment to be made after 30 days. Subsequently, after 20 days, the cow died. That means there is no subject matter. Performance cannot be done because the cow is died. So, originally it was a valid contract. On destruction of the subject matter, when the cow died, there is no subject matter for the contract. It becomes a void. So, contract was a valid contract. Subsequently, it has become. So, void contract, there are two things. So, a contract may be void from the beginning, or contract may be void subsequent to this. So, now the section, there are some sections which classify the agreements as void. We will take one by one. Section 20 of the Contract Act says, if there is a bilateral mistake, the agreement is void. There is a condition. The mistake should be by both the parties. It should be to the material fact, essential to the agreement. If these conditions are satisfied, then the agreement is void. If it is a mistake by only one person, then it is not void. It will not become void. To make the agreement as void, the mistake should be by both the parties. It should be a material fact, essential to the agreement. This is section 20. We have already seen when we are studying the free consent under mistake. Next is Section 23 and 24 deals with the unlawful consideration and object. This also we have already seen. Unlawful consideration and unlawful object, there are 5 conditions. That is, if it is forbidden by law, if permitted it will go against the law, then third it is fraudulent, fourth is involves injury to the property or person, fifth is considered to be immoral and public policy. If these conditions are there, then it is a unlawful consideration or unlawful object. This makes the agreement as void. Then the third one, it is absence of consideration. Section 10 dealing with the valid agreement says consideration is required. Section 25 clearly says that in the absence of consideration the agreement is void. But it gives 3 exceptions to that. This we have already seen when we are seeing the chapter on consideration. The exceptions are when the agreement is written and registered, executed out of love and affection between the near relatives. If these conditions are satisfied, no consideration is required. Love and affection, and it is between the near relatives, it is a registered and it is in writing and registered. This is the first one. Second is any agreement for a past voluntary act is exempted, no consideration is required. The third is if it is for a payment of time or debt, no consideration is required. This is according to section 25. Other than these 3, consideration is required. If there is no consideration, agreement is void. Then the section 26, any agreement restraint of trade is void. If there is an agreement that you should not marry, it is a void, because it is his natural right to marry a person, marry a girl or marry a boy. This is a natural right. If somebody is taking that right, it is void. That is section 26. Then next is the section 27. Section 27 says if there is a restraint on trade, then it is void. Everybody has a right to do business. It is guaranteed. You can do your own business, you earn income. But if there is an agreement in restraint of trade, then it is void. It is section 27. But section 27 gives one exemption. If a person is selling the business, there may be reasonable condition restraining the person from taking the business in the same area, locality, or in the same business. Some reasonable restraint may be put on the person who is selling the business. Condition may be put by the buyer of the business. Apart from this, Partnership Act also permits a restraint of trade. 3 cases. When one person goes out of the business, retiring from the partnership, then the remaining partner can put a condition on the person going out that you should not take this business, and they may put a reasonable condition on the retiring partner. The continuing partners in the business, they can put a condition: the person who are on in the partnership firm should not take up this business in this area. Like that, a reasonable condition may be put up between the existing persons. In a third case, if the partnership is dissolved, everybody has closed the business, then they may agree that not to take the business. So partnership gives 3 exemptions. One is in the case of retiring partner, he may be restrained from doing the business. In the case of continuing partners, all the partners may agree not to take up the business. And in the case of retirement, in the case of dissolution, the partners may agree not to take the business. Some reasonable conditions they may permit. Apart from this, the courts also permit some restrictions. An employer may restrict the employee from taking up an employment from his competitor after leaving his job. A reasonable condition may be put not to take the employment from his competitor. One wholesale company may put a condition to the retailer that he should not deal with other company product. For example, Maruti company may put a restriction on its retailers not to take the vehicle, not to deal with the vehicles of the other companies. Like that, associations may also put some conditions like regarding opening hours, opening business hours, closing business hours, like that they may also put a reasonable condition. Other than these exemptions, if there is any restraint of trade, then it is void. Then next section 28 deals with the legal proceedings. If there is any condition regarding restricting a person from going for legal for establishing his legal rights, then it is not valid. A person has a right to get justice. If the agreement takes that right, then it is void. Next is when the terms are uncertain, the agreement is void. This is section 29. Already when we saw the offer, we have dealt with this. The terms of the offer should be certain. For a valid offer, the terms offer should be certain. That we have seen when we are seeing the offer. When the offer is accepted, it becomes a contract. The contract, that term should be certain or capable of means made certain. That section 29 as an illustration. If an oil merchant has entered in an agreement for sale of 100 tons of oil without mentioning what type of oil, then it is not certain. The contract is void. But if it is entered by a person who is dealing only with coconut oil, you can presume that 100 tons relates to coconut oil. This is being made as certain. Originally it was not certain. Since a person is dealing only with the coconut oil, the court may presume that this is for the transaction is for the agreement is for coconut oil. In that case, the agreement is valid. The section gives two illustrations. One is 100 ton of oil where the agreement is not certain because the seller is dealing with so many oils. In the second case, it is 100 tons of oil, but the dealer is dealing with only the coconut oil. Though we can presume that it is for coconut oil. Then the next is wagering. That wagering we will see in the next session.